Hi, my name is Alex Dolphin, and welcome back to another episode of Ex-Ante. Today we're going to discuss the case of Wagner Excello Foods Incorporation versus Fearn International Incorporation. This case was heard in the year 1992 in Illinois State Appellate Court. This case deals with a business agreement, one that Fearn would like to call only an agreement, and one that Wagner would like to call a contract. The agreement was that Wagner would manufacture and distribute juice units for Fearn. And when we're talking about juice, we're talking about frozen juice concentrate. So think old school, like orange juice that you would grab out of a can in your freezer and put into a pitcher with water and stir it up. The term of the agreement had two terms that we're going to spend some time on. The first was that there was a minimum threshold of units that needed to be purchased from Wagner by Fearn over a 5-year period. The second was that the price per unit was open. It was a nuanced agreement that the two parties had come to. That was that there would not be a specific price over the full 5-year duration of the agreement. Rather, the price would be agreed to in 4-month intervals. So every 4 months, Wagner would come to Fearn and say, hey, we'd like to sell the juice at 10 cents per unit. Fearn could say, yep, that sounds great to us, let's continue. Or Wagner might come and say, hey, we'd like to sell the juice at 20 cents per unit. And then at that point, Fearn might say, that's too high for us. We don't want to buy the juice at that price. We'll just go ahead and be done with the contract at this point. Agreement, rather. So at the end of 5 years, there hadn't been any disagreements on price under the nuanced method that they would come to prices. And the agreement seemed to work well. Ultimately, though, Wagner wasn't happy because Fearn hadn't reached that minimum threshold of units purchased in their agreement. So they brought suit. They said that you owe us $3 million in lost profits because you didn't reach that minimum threshold of units purchased. Fearn's defense to this was that there was never a valid contract because the price term of the agreement was open. It was left open and it was never set in stone and concrete, and for that reason, there was never a valid contract. Those are the arguments of the two parties. The issue at hand is, can a contract be valid if there's an open price term? And if so, how can the court reconcile that? So let's go ahead and jump into the ruling. So the court notes that the UCC, so the Uniform Commercial Code, which is reference law and contract law, does have provisions allowing for an open price in a contract. The provision pivots on the mutual assent of both parties to that term, to the term of an open price. So both parties have to assent to an open price point in their contract for it to be valid. Fearn argued that there was no assent on their side, and Wagner argued that, yeah, of course there was assent. That's how we had the agreement. But ultimately, the court wasn't going to find that fact. What they did was they just remanded the case to a lower court, and they said that the trial court needs to figure out what the intent of Wagner and the intent of Fearn was when they were forming this agreement. And if it was an intent to leave this price point open and to meet each other on the rest of the terms, then that would be a valid contract. So they ruled in favor of Wagner in this case, but Wagner still has more work to do in the trial court. All right, so let's go ahead and jump into some ex-ante implications. First being that it does incentivize parties to agree to a clear price term in their contract. This is just because even though the court does rule in favor of Wagner in this ambiguous price point, just shows that if you have an ambiguous price point, it can lead way to future litigation. So it does incentivize in an offhand way parties to just actually agree to a concrete number in their contract. And second, I think most importantly and finally, this ruling does disincentivize bad actors, malicious attorneys, folks who are trying to take advantage of other parties from leaving open terms in contracts or agreements, as Fearn would like to say, from leaving open terms there in hopes of one day going to court and saying there was no valid contract and this was just a business agreement. So thanks so much for watching. I hope you have a nice rest of your day.